Are you an Indian citizen? Whenever we fill our personal information in any application or registration form, this question always pops up. Have you ever wondered why? Well, because this is a major part of one's identity. At the most basic level, a citizen is defined as a person who is legally accepted as a member of a particular country and who has rights because of being born there or because he or she is being given those rights. Being a citizen of India, there are certain rights which are given to an individual. For example, when we will discuss Fundamental Rights chapter, there we will discuss that there are some fundamental rights which are exclusively available to the citizens of India. For example, Article 15, Article 16, Article 19, Article 29, Article 30. These are the fundamental rights which are exclusively available to the citizens of this country. For example, it is only a citizen who has a right to vote, the right to equality of opportunity in the matter of public employment, the cultural and educational rights under Article 29, exclusively available to the citizens of India. It can be said that these rights give a sense of belonging to individuals. That being said, there are also certain duties that a citizen owes towards the Indian state. And that's why we say citizenship is like a symbiotic relationship between the citizens and the state. The state confers on citizens certain rights, and citizens in turn have certain duties towards the state. For example, as citizens, we shall uphold the unity, integrity, sovereignty of India. But if you want to understand what exactly is citizenship, this is something, a beautiful quote given by Hannah Arendt, a political theorist. She says, citizenship is the right to have rights. Now, when it comes to citizenship, normally, this is something which is not mentioned in the Constitution. If you look at the Constitution of various countries, citizenship as a chapter is not normally mentioned there. But India is unique. Why? August 15, 1947, we got independence. But at the same time, there was a partition as well. Unfortunately, on the grounds of religion. There was a massive migration of people from India to what became Pakistan. And there was a migration of people from Pakistan back to India. So when the Constitution was being enacted, we had to be absolutely sure who are the citizens of India. And that is why this chapter is mentioned in the Constitution. But to be clear, Constitution does not define the entire concept of citizenship. This matter is left to the legislature. When we will discuss Article 11, Article 11 gives unfractured power to the Parliament, to the legislature, that you regulate all matters related to citizenship. And Parliament has done that. The year was 1955, when Indian Citizenship Act was enacted. But at the same time, what are these constitutional provisions that are mentioned under Articles 5 to 10? That is something that we will discuss today. Similar to any modern state, the population of India can be divided into two broad categories. Or should we say all those who are residing within the territory of India, we can broadly divide them into two major categories: citizens and aliens. Who are the citizens? Those who share this symbiotic relationship between the citizens and the state, those are citizens. And then there are aliens. Who are these aliens? Basically foreigners who are residing in India. And these aliens can be further categorized into two broad categories: friendly aliens and enemy aliens. Who are these friendly aliens? Citizens or nationals of United States and India, nationals of Britain and India, nationals of France and India, basically citizens of those countries which share good relations with India, citizens of those countries who share friendly relations with India. The citizens of those countries in India, we call them friendly aliens. And who are these enemy aliens? Citizens of those countries with which India is at war. Now that we have primarily established who is a citizen in Indian context, we can look into the concept of citizenship at a broader level and various elements related to it. One can view the idea of citizenship as a legal contract between an individual and a nation state. It's a legal status and relation between an individual and a state that entails specific legal rights and duties on the individual. Now the question is, who gives this legal status? Well, in case of India, it is our Constitution. Articles 5 to 11 under Part 2 of the Constitution deals with citizenship. However, as I told you before, it does not deal with any permanent provision relating to citizenship. You must be wondering what I mean by that, right? In simple terms, the Constitution only describes different categories of persons who became citizens of India at its commencement. And you would know 26 January 1950 is the date of commencement of the Constitution. The Constitution empowers the Parliament that you enact laws in case of acquisition of citizenship, loss of citizenship, or any matter related to citizenship. Article 11 of the Constitution, which reads as Parliament to regulate the right of citizenship by law. And it is this Article 11 which gives unfractured power to the Parliament that you make laws regarding citizenship. And that was 1955, when the Indian Citizenship Act was enacted by the Parliament using this provision, Article 11. We will look at the Indian Citizenship Act in detail, but in a while. However, let us first understand the different categories of persons who became the citizens of India during the commencement of Indian Constitution, that is, on 26 January 1950. When India got independence, on August 15, 1947, it got divided into two parts, India and Pakistan. Due to this, large-scale migrations happened. People moved from Pakistan to India and vice versa. Even after partition, for almost 1 year, there were no restrictions on the movement of people between the two countries. To regulate this, a permit system was imposed on July 19, 1948. This meant that now, for moving from one country to another, one has to take permission from their respective governments. So even after this permit system, people migrated from one side to another, but now with the permission of the government. This was done to scrutinize those who were migrating. You can think of it like an alternative to the modern day visa and passport system. Now, if we speak about India, there would be many people who would have moved out of the country. There would also be those who had come to India, or even there would be Britishers who had stayed in this country even after independence because of their own will. For such cases, how would one decide who will qualify as a citizen of India? You must be thinking that this is so easy, but hold on. We're talking about the time around August 15, 1947. And the Constitution came into effect on January 26, 1950. Confused? Don't be. The answer to all these complicated questions are given to us in Part 2 of the Constitution that deals with citizenship. We will first see Articles 5 to 8 in detail. There are two things that we need to look at in all these articles. One is to understand their target population, that is, on whom any particular article applies. And the other is the conditions under which that particular article is applied. Article 5, for example, is about citizenship at the time of the commencement of the Constitution. The first condition is a person was born in India, or if either of his or her parents were born in India, or if one has been a resident of India for 5 years immediately before the commencement of the Constitution. The next article is Article 6. It's about the rights of citizenship of certain persons who have migrated to India from Pakistan. This article is applicable on people who migrated to India from Pakistan. The conditions to qualify as a citizen under this article are decided on the basis of the fact whether a person has migrated before or after July 19, 1948. Why July 19, 1948? Do you remember the permit system that was introduced on this date, due to which only people with prior permission from the government would migrate? Yes, that made this date a significant one. Let us look at Article 7. It's about rights of citizenship of certain migrants to Pakistan. This article is applicable on people who went back to Pakistan after March 1, 1947, but came back to India by January 26, 1950. For this, he or she had to be a resident of India for 6 months preceding the date of his application for registration as a citizen. You must be wondering, what is the importance of March 1, 1947, right? Well, this was the day when the chaos regarding partition actually began, due to which lakhs of people started migrating. Article 8 of the Constitution is about rights of citizenship of certain persons of Indian origin but residing outside India. Like the name suggests, this was applicable to people of Indian origin residing outside India. The condition for such people was that either the person or one of his or her parents or grandparents must have been born in undivided India. Such a person could go and register himself as a citizen of India by the diplomatic or consular representative of India in the country of his or her residence. These 4 articles dealt with 4 different categories of people who could get citizenship. However, there are other constitutional provisions too related to citizenship. Let us look at them in the next video. Article 9 states that persons voluntarily acquiring citizenship of a foreign state not to be citizens. For example, there is an Indian who has voluntarily acquired the citizenship of a foreign country. Now this individual will no longer be the citizen of India. Why? Because we do not value dual citizenship. That means you can be a citizen of India and India only. At the same time, you cannot be the citizen of United States. At the same time, you cannot be the citizen of Germany. United States, for example, it recognizes dual citizenship. So you can be a citizen of United States and at the same time you can be a citizen of any other country. But India recognizes single citizenship only, which means you can be only the citizen of India and not of any other country. That is why if you are voluntarily acquiring citizenship of another country, you are no longer the citizen of India. Article 10 talks about continuance of rights of citizenship. This means that Article 5 to 8 decides the application and condition of who can be the citizen of India up to 26 January 1950. Such people will continue to be the citizens of India until the Parliament passes any law which does not recognize them as citizen anymore, or in case of citizenship cancellation, which basically means Article 10 would provide us with a situation whether those citizens who were granted citizenship till 26 January 1950, even after that, will they continue to be the citizens of India? This means that Article 10 gives this power to the Parliament to take away the citizenship of people who have already been given the status of citizens under Part 2 of the Constitution. Besides this, Article 11 gives the power to the Parliament to make any provision on matters of acquisition and termination of citizenship. This was needed because the provisions to grant citizenship to people who came to India after January 26, 1950 was not provided in either of the Article 5, 6, 7 or 8. Thus, Article 11 is for Parliament to regulate the right of citizenship by law. For the same purpose, the Indian Parliament passed the Citizenship Act 1955. We will look at this act in greater detail in the next section.